All right. Well, good afternoon, everyone. Welcome to today's Lunch and Learn CLE. We're expecting a pretty good sized group today, so we'll give it another minute, and then we'll let everyone get situated. All right. Well, let's go ahead and get started. Again, good afternoon. Welcome to today's CLE. My name is Sean Moman. I'm the chair of the ADR section of the Georgia Bar. We're quite excited about today's CLE. And it just happens to be the type of week that we've got two programs on arbitration this week. It's usually not the case. We like to do one program at least every month, but it just turned out that we've got two this week, and they both happen to be in arbitration. So we'll call it the week of arbitration for us. But we're quite excited about today's program. It's something that we've talked about within the executive committee for quite some time. We want to ensure that those new arbitrators that are getting into the field and looking to get some support and help with their first arbitration, we're hoping that this program today is really going to help you out. So what I want to do is I want to introduce Sam Sparks, who is the lead and moderator for this particular program. Sam is a member of our executive committee for the ADR section of the Georgia Bar, and he's also the vice chair of the Atlanta Bar Association's dispute resolution section. He's been a full-time neutral since 2019 and a member of the Georgia Bar since 1981. And most of Sam's career has been in the construction industry. He's served as general counsel for two large home builders and also in various senior management roles for two Fortune 500 companies. Sam has acted as an arbitrator and mediator in numerous small and large cases throughout the Southeast and as a panel member of the American Arbitration Association, as well as a construction dispute resolution services. Sam, I'll turn it over to you to take it forward. Thank you.
All right. Sean, thank you very much. I appreciate the opportunity to be here today. So this will be a panelist presentation today, and let me introduce my panelists. Number one, Jennifer Grippa. Jennifer is with Miles Mediation and Arbitration. She has 24 years of courtroom trial conflict experience. She's a former partner and construction practice leader of a large 150-member law firm, and is double barred in both Florida and Georgia. Florida Supreme Court certified mediator, registered neutral in the state of Georgia, and a super lawyer in the area of ADR. She resolves complex litigation. She's been a full-time arbitrator in the area and mediator since 2016. Her mediation and arbitration experience has involved public and private projects, commercial, industrial, aerospace, governmental infrastructure, multifamily, residential, and residential projects. She's experienced in design builds, joint venture, construction management, project management, and other contractual arrangements and delivery systems for complex commercial projects. Welcome, Jennifer. We're happy to have you here today.
Thank you.
Okay. Our second panelist is Henry Quillian. He nationally litigates, arbitrates, and solves commercial disputes in the construction, real estate, insurance, and intellectual property and general business sectors. Henry mediates and arbitrates with Bay Mediation and Arbitration, as he has for the past 12 years. He's resolved disputes in the areas of construction, real estate, insurance, intellectual property, and general business sectors. For over a decade, Mr. Quillen served as chair of the construction practice at Taylor English, and he was voted by his peers as a top 100 lawyer for 12 consecutive years in the Georgia Super Lawyers Poll, and has been selected since 1997 as one of Georgia's Legal Elite by Georgia Trend magazine. From 2013 to 25, he was selected for the best lawyers in America. He's AV rated by Martindale Hubble. Welcome, Henry.
Thank you. Good being with y'all.
Okay. And our third panelist is Gautam Reddy. Gautam focuses his practice on construction and infrastructure projects. Gautam is with Kilpatrick Stockton. He represents a wide variety of clients in the construction industry, including owners, EPC contractors, subcontractors, design professionals, not only in the U.S., but internationally. His practice includes front-end contract drafting and negotiation, counseling contracts during projects, and litigating cases in a variety of forums, including state and federal courts. Domestic arbitration, international ICC arbitration, and on the Civilian Board of Contract Appeals. Mr. Reddy's experience includes large industrial mills and processing facilities, airports, hospitals, transportation infrastructure, pipelines, commercial developments, university facilities, and mining projects. Mr. Reddy was recognized as one of the best lawyers in America in 2024 and 25 for construction law. So let's get started, everybody. What we'll do today is we'll start off, each of the panel members has submitted some information to me, which I think has gone out to everybody. But I've got some topics I think would be useful for everybody to talk about. So let's get started. Number one, if anybody has questions, you can go ahead and enter them into the Q&A portion of the app. But we probably won't get to them until last. So I may try to cover them as we go along, but we'll see where we go with that. So let's get started. Jennifer, how do you get started in an arbitration? Say you've got the first case and your client wants you to file an arbitration. How do you do that?
Well, the first thing to get filed is the demand. And in order to prepare the demand, you first have to look at the contracts because arbitration is a creature of contract. So you've got to pull together the contract, and there may be more than one contract. So there are certain scenarios where there might be a master contract, and then the parties enter into additional contracts or scopes of work that could also have terms in there that are important. In construction, I see a lot of times where there's subcontracts or even other contracts with other providers that may end up being third parties to be joined to the case ultimately. So you want to be looking at those contracts ahead of time before you file the demand. Look specifically at the arbitration provisions in there. There will be a spot on the demand that asks about the qualifications of the arbitrator. And some contracts put in there, we need an arbitrator, or the parties agree to arbitrate with somebody who has design experience or 20 years experience doing energy or what have you. And so if there is anything particular that these parties have contracted to in that arbitration provision, you need to be mindful of that when preparing the demand. But basically, the demand is going to be much less formal, I would say, than a complaint. You'll want to include the background information. What are the specific claims? And be specific in terms of negligence, contract, that sort of thing. And also lay out the damages, because depending on what venue you're in and who has jurisdiction, it could vary based on what the amount of the filing fee is based on what your claims are. And then also be mindful of the rules. Obviously, read the rules, find out what rules apply, and read them before you go filing your demand. So sometimes the parties state in the contract what arbitral body is going to have jurisdiction over that. And so you obviously need to read that to determine, where are we going to file this demand? Is this a AAA arbitration? Is this going to be an ad hoc arbitration? Do we have to agree on the arbitrator? All of that is something that you have to know on the front end, obviously, before you prepare the demand.
Okay. Panel, anybody want to add to that?
I'll add something real quick. I think Jennifer did a good job of the overview. Under the AAA, especially for construction disputes, there are some alternate tracks you can elect. We've done the fast track procedure a couple times where I think it's the amount in dispute is under 100 K, where it's an expedited, like 45-day hearing process, very limited discovery. Depending on the amount in dispute, that's a quick way to potentially resolve something that doesn't really warrant the fees of a full-on arbitration. If I recall right, there's also an option for just doing it on the papers, just written submissions, which again, if it's a smaller dispute, that's a potential way to minimize the fees and if both sides are comfortable and the client's obviously comfortable with that to go that route. But I think otherwise Jennifer really covered everything.
I was going to
Okay.
note a comment that came in, which is this appears to be very construction specific. It just happens to be that there's a lot of arbitration in construction, but all this would actually apply to any type of arbitration. In particular, although the AAA does a lot of construction arbitration, it also has commercial rules. It has all sorts of different practices and that can be pursued in arbitration there. So it just
Yeah.
happens to be that we happen to be construction people, but that tends to lead to more arbitration.
Well, and to be fair to everybody, I'm just going to say that I'm on the AAA panel, but there's other panels that are around. For example, JAMS has got its own set of rules, and they're not the same as AAA's, but they're similar in scope and format. And I'm on a panel of another construction dispute provider. So you have to look at the provider's rules, and that's an important part of what you're doing. And actually, those rules will kind of paint the path for you. So let me ask another question here. When I first got started, everybody was talking about the FAA. And, after scratching my head a little bit, I realized we weren't talking about airplanes. So Henry, tell me about the FAA versus the Georgia Arbitration Code.
So generally speaking, it's a good thing for y'all to know in order to figure out where you're heading, what playing field you're on. And I noticed that a lot of home purchase contracts have the Federal Arbitration Act listed as the prevailing statute that governs the arbitration. And that is a very old statute from 1925, which predated, for you youngsters, the Federal Civil Procedure Act, any invention of discovery whatsoever. And it was an intent to have an opportunity for people to go to arbitration and to be forced into arbitration if they agreed to it. As Jennifer was saying, arbitration is a creature of contract. It's just sort of backed up and enforced under statute. Well, the Federal Arbitration Act, essentially, in my mind, if you have nothing else that you're relying on, leads to perhaps a very efficient arbitration, but all sorts of limitations you wouldn't expect as far as being able to get non-party discovery, which can make your arbitration less expensive, but it also can mean if you're the party that's sort of on the outside of the fact pattern, having a very hard time getting or figuring out what your case is until you basically bring everybody to the hearing and have a wild, wild west proceeding. On the flip side, the Georgia Arbitration Code is much more liberal and more like, has the opportunity to be more like a litigation where the arbitrator can decide whether there's going to be any discovery or not, and also whether there's going to be pre-trial obtaining of documents and depositions. So that's sort of a basic outline. There's a lot more said in the paper, and we can discuss it in whatever depth y'all want to do that.
Okay. So, Gautam, I know you do some defense work. So if somebody files a demand against one of your clients, what do you do when you get it?
Well, obviously first, review it carefully. Think about potential enforceability of the arbitration agreement, depending on, whether you want to be in arbitration or not. Think about whether there's any necessary parties, where joinder may be necessary, or consolidation, whatever the case may be. There's a whole complicated process regarding joinder under at least the AAA rules called an R7 process. That's probably beyond the scope of this presentation, but there's all these various considerations, especially in the construction context where there usually are more than just two parties involved in a potential dispute. So think through all those things, and then once you've kind of gone through those initial procedural hurdles, look at the substance of the demand itself, and see what you want to obviously answer with. That is one of the key differences, I think, between litigation and arbitration is that you do not have to answer an arbitration demand. You have 14 days to do so if you want to, but if you do not answer, the demand is deemed denied. So there's some different schools of thought on whether to answer or not. If it's a low amount in dispute, whether it's worth the fees to put together a responsive pleading. I think in bigger disputes, it's always worth it to answer, just so you can get your story across to the arbitration panel at an early stage. I mean, think about this, where if you've got a bigger arbitration. And let's say you're in the middle of the arbitration and you've got a check-in with the arbitrators, or a discovery or evidentiary issue that the arbitrators want to hear. And obviously arbitrators are busy, they might not be up to speed or remember your case. And what they're going to do is go back and read, the demand and then hopefully an answer, right? And if there's just a demand on file, they're only getting or refreshing themselves on one side of the story, and they're not hearing, your client's side, at least in writing, right? So I always think, unless it's really a small dispute, file an answer, put something together, especially in the construction context where there's usually counterclaims coming across the other way too. If you're doing a counterclaim, you're generally also addressing, the allegations in the demand as well. So I think generally it's worth it to put together an answer to a demand.
Okay. So Jennifer,
I would
Go
just add to that, in the context of other arbitrations, like an employment arbitration, even more reason why the employer might want to put something out there responding to things that a former employee has put into a demand. And then the same thing, we're seeing more and more nursing home negligence arbitrations. And arbitrations in healthcare contexts, arbitrations between partners, medical practices, and things like that. So it's not just in construction, but in those contexts, to Guadam's point, the other side, putting that in writing can be helpful if you want to bring the arbitrator's attention to certain things in terms of the defenses.
Well, speaking as an arbitrator, all are exactly right. First thing I do when we're going to have a hearing is to go back and look at the demand and look at the responsive pleadings. Now, it is interesting. You see a lot of times you see lawyers that file a formal answer raising all the statutory defenses, and I'm not really sure that's necessary. But what is important is to tell the arbitrator really what your defense is about. As clear and as factual as you can.
I was going to mention one other thing that's often the case, and this but sometimes there's a pre-mediation prerequisite to the commencement of arbitration. So if you ought to make sure you read your arbitration clause carefully, as Jennifer was saying, because you might have a false start if you haven't mediated first, and that's a condition precedent to filing the arbitration. And you might spend a lot of money on that arbitration panel fee without when you didn't have to, because you might have gotten it resolved in mediation.
Yeah, that's a good point. So Jennifer, after the 14 days for the answer, the responsive stuff is coming by. What do you think is going to happen next?
Well, the case manager will reach out to the parties and schedule a preliminary hearing. And the preliminary hearing is your first opportunity to get in front of your arbitrator. And so it's an opportunity for you to be prepared. And to do that, you want to look at the scheduling order or a checklist, depending on what forum you're in. At Miles, we have a preliminary checklist so that the parties can know what the arbitrator wants to see when you show up to the preliminary hearing. AAA will provide you a form agenda so that the parties can kind of have an outline of what things are going to be discussed. But I would say from the arbitrator's perspective, the goal is to come out of that preliminary hearing with a final hearing date set, an interim deadline set, so that we know how the case is going to proceed and how we are going to get it to a final hearing. I would say one of the biggest pet peeves I have as an arbitrator is when people come to the preliminary hearing and they have their own calendars, but they have not checked with their clients. They say, I gotta go check with my client. I don't know if I can do these dates. Or they know that they have witnesses. Some of them even have reports from witnesses, but haven't checked with witnesses. And so it's a small thing, but check everybody's schedules ahead of time, find out what dates will not work, so that at the hearing that can be set. I would also say at the hearing, we talk about, are there any preliminary things to be covered? Are there going to be motions on arbitrability of certain things? Is somebody going to claim that they're not subject to arbitration? Obviously, we don't want to put a final hearing date in place and have things delayed by motions and other things that should be addressed on the front end. I would say that we also discuss any issues like joinder. If third parties are going to be brought in, we need to do that process right away. And usually it's done before even the merits arbitrator is appointed in the AAA process. That's how it would work. And then other things that could discuss, what is the scope of discovery? Is there going to be any discovery? And if so, what does that look like? So come prepared to talk to the arbitrator about the realm of documents to be exchanged and the information that you need to really be ready to try the case. That's going to be what's most helpful to having a productive preliminary hearing and getting a scheduling order in place so that we can move forward to a final hearing.
Well, Jennifer, you raised some good points. You know, one of the things about arbitration is it's supposed to be faster and quicker. And Gautam, you mentioned the fast track procedures. Some of the fast track cases are expected to go to final hearing within 45 days under the AAA rules. And I suspect, again, under JAM's rules, I think, and Miles may have an accelerated process also. So, you know, the whole idea of it is to not spend time on things that are not important, but to spend time focusing on the important things. So, as you say, come prepared, ready to talk about that stuff. It's not uncommon to deal with discovery and whatever limits there needs to be. And, you know, you can tell a lot of times experienced arbitrators in that initial hearing, they'll come in the door and they'll know, I got to have one deposition, you know, but so, you know, you won't get somebody that says, oh, I got to have 10 depositions. That would be a little bit out of the norm, even in a big construction case. So let's talk about discovery. And I'd like Gautam and Henry both to respond to this. So what about discovery in an arbitration case? What can you get?
Well, I guess I'll quickly start. I mean, a lot of it obviously depends on, you know, the give and take with opposing counsel, but I mean, one of the benefits of arbitration is it's entirely customizable, right? It's usually not to the full extent of federal court discovery, although, you know, if you want it to be and the other side agrees, you can certainly have federal court style discovery. But really, it's trying to find a middle ground with the opposing party in terms of, like you said, how many depositions to take, whether there is a procedure in place in the scheduling order to both apply for and you know, have motions for summary judgment. You know, I know Henry's going to talk about non-party discovery, but that's also always an issue in arbitrations from a procedural standpoint. Yeah, I mean, in terms of depositions, there's always the number of depositions or whether you just have an hour limit, and the parties can kind of depose as many witnesses as they see fit within that hour limit. There's, you know, how the scope of discovery is determined, whether both parties just produce documents in support of their claims or whether there's more targeted document requests and, you know, kind of the standard both parties kind of need to adhere to in terms of the rigor they apply to collecting documents from custodians. Oftentimes parties do agree in terms of custodian discovery to, you know, collect documents from, let's say, 3 document custodians and then apply, you know, 10 search terms or something like that to really limit what they need to collect from their client. So I say that all that to say there's a lot of customization, and it's one of those things where, you know, before you go into a conference with opposing counsel or with an arbitrator to determine all these various different parameters for discovery to really think hard and even confer with your client about what do we really want? You know, do we want more depositions, less? How extensive do we want discovery to be? Really think hard through those things, especially if you're a federal court litigator where you don't really have to have these decision-making points, because arbitration is so customizable in that regard.
So
Okay.
one thing that's actually interesting about arbitration is if the parties thought a lot about their arbitration clause before they even entered into the contract might set out all those limits on discovery, sometimes overly aggressively limiting the amount of discovery. Sometimes it's very reasonable, like 3 depositions max, an exchange of documents, etc. I've never had an arbitration where the arbitrator wouldn't allow and force an exchange of documents. In fact, the Georgia Arbitration Code expressly says you're entitled to that. But one of the additional things I wanted to cover in connection with the Federal Arbitration Act versus the Georgia Arbitration Code is that even though if there's interstate commerce involved, the Federal Arbitration Act might be involved for the purposes of getting you into arbitration, making sure it happens. Other rules can be applied, and if you agree in advance that other rules will apply, the Georgia courts will enforce the application of those other rules, which does, as mentioned, expand the opportunity to do discovery if the arbitrator allows you. I've certainly been in arbitrations where the arbitrator just said, small case, not much at issue, no discovery. You know, the exhibits to the arbitration demand and the exhibits to the answer are the ones that will apply to a great degree, in addition to the testimony of some witnesses. And so if you're trying to avoid discovery, keep in mind a case mentioned in the paper called Managed Care Advisory Group, LLC, because if the Federal Arbitration Act applies, that 11th Circuit case from 2019 can be used to crush a lot of non-party discovery. And it might also limit the discovery to people actually bringing under a summons paperwork to the actual hearing. In which case, if it's complicated matter with a lot of papers, you better have a team ready to review those documents when they're brought by a non-party, if they indeed comply with the subpoena. But in general, because of the and I would be interested from Jennifer and from Sam on this, because the evidentiary rules are substantially relaxed, it may be that you can get a lot of things into evidence that you think are going to be sort of prima facie reliable, like Georgia power bills or something like that, without having to have discovery or any extra testimony to support them. Is that correct?
I'll let Jennifer respond and then I'll pick it up.
Well, I think that I've seen a workaround happen where we actually notice of the hearing and then begin the hearing and then have these documents delivered, but then suspend the hearing and resume to start it on another day to kind of get around the managed care decision that you mentioned, Henry. Now, I don't know that happens often, but you know, I've seen parties agree to do that for the specific purpose of getting those documents in. As far as, you know, the admissibility of things like Georgia power bills and whatnot, usually the lawyers are going to stipulate to authenticity of that and not have to have custodian records. And I mean, I have not come across that where there is such disagreement on the admissibility of that, because those evidentiary standards are relaxed. I don't think many lawyers spend the time making those types of arguments on terms of the admissibility.
So let me pick it up from there. You know, an arbitration is kind of like trying your case in front of a judge where there's no jury. Now, if the judge is going to have to make findings of fact and conclusions of law, that's one standard, and that's a possibility in arbitration. Although I can't say that I've ever seen it, because usually when people find out they got to pay a court reporter to do the transcript and all, that whole concept goes away. So usually the decisions that are coming out are what they call a reasoned decision, where the arbitrator responds and kind of outlines how he got or she got to her decisions. Um, but the question touches on one concept, and I've seen we've had a couple of questions about this. So traditionally, people take depositions for the purpose of building a motion for summary judgment, right? Does that happen in arbitration?
It can, but I know we'll kind of get into this, but motions for summary judgment, I would say, are less common in arbitration than they are in litigation, and we'll get into that. But I think in terms of deposition strategy and arbitrations, at least from my perspective, a lot of it is more true discovery, trying to find out what this witness knows, what they're going to testify about at the hearing, what the extent of their knowledge is. I think it's less common for the purposes of summary judgment, and sometimes people use depositions to test, how the witness would hold up to tough questioning in front of a jury. I think that's somewhat of a fair consideration in terms of how they'd hold up in front of an arbitrator, but it's a little bit less of a concern because, arbitrators, tend to focus more on the facts rather than, on the demeanor of a witness as a jury might. So in terms of, how I take depositions, usually it's more, like I said, on the facts that the witness knows and trying to foreclose certain areas of testimony they don't have personal knowledge about, rather than trying to develop a record for summary judgment, unless the case is one where I think, summary disposal may be appropriate.
And of course, you might have a witness who's out of state. There's no way to drag them in. And if they're willing to cooperate and give a deposition, you can do it in the form of a preservation of evidence deposition, and then play it at the arbitration.
Yeah, and it's not uncommon. I get this phone call as an arbitrator. It's not uncommon at all that we have them testify via Zoom live or even via deposition, via transcript. There's a lot more flexibility in how that works out. It generally becomes, except in the very biggest cases, pretty much a non-issue. So balancing our time here a little bit, let's talk about hearsay for a second. This is kind of relevant to this. What happens when you have a hearsay objection in arbitration? And Jennifer, I'm going to ask you to pitch in right there.
Well, like we said earlier, the evidentiary standards are relaxed in arbitration. We don't have the concerns like we do in front of a jury that they are going to hear evidence that will sway them that should not be admitted. Presumably, when you're in arbitration, your arbitrator is someone experienced at deciding these types of cases and weighing the evidence, and is not going to be, and is going to, I guess, take it for what it is in terms of hearsay. So there isn't a great deal of emphasis on these types of evidentiary objections on hearsay. I would say some arbitrators will even say it's admitted. There is no hearsay objection. It's all coming in, and we're going to give it the weight and credibility it should be afforded.
That would be my response too. Again, there's not a lot of motion practice in that kind of an arbitration case. Now, I think it's relevant to talk on one of the questions here. We got a question here about a motion to dismiss. So the first thing I would say is, does the arbitrator have to allow motions to dismiss or motions for summary judgment. Is that something that he or she can do or not do? What's your thoughts? Henry,
Well,
I'll
they
pick
don't
you.
have to, they don't have to, that's for sure. A motion to dismiss never even had that come up. Now, that would only be in the circumstance where there's no arbitration clause or something like that, simply not arbitrable. Whereas a motion for summary judgment under the AAA rules, you have to ask permission and give a persuasive reason for why that would be even accepted by the arbitration panel. But got them, Jennifer?
Yeah, I would love for Holly to just, if she could, if she's still listening, to just say in what context that would apply. I'm not saying that it would never happen. It might be rare, but I have seen cases where there are dispositive motions filed with respect to contractual provisions. There may be something on an indemnity provision that the parties need clarity on that would be addressed on motions ahead of the evidentiary hearing. And so that kind of scenario I can see happening.
Yeah, I've had it happen a couple of times where we've had people that denied executing the contract that's not with that contained the arbitration clause. So that's an arbitrability question at its face. And so you might have a hearing of that sort of thing. But generally, and I think most arbitrators would tell you this, the time and effort it takes to resolve a motion for summary judgment or even a motion to dismiss is really probably more even than what it would take to resolve the case at trial. And so that's what, now if you're in a big case, and the question was, what's the difference between a small and a big case? But in many of the construction cases, the claims run well north of $1 million. Well, that's a little bit different answer. So you're going to have to think about that. But the arbitrator's job is to try to craft a remedy that's appropriate for the dispute that's there. So let's talk a little bit about the hearing. So the trial in an arbitration world is called an evidentiary hearing, right? So let's talk about, I'd like all three of you to respond to this. What about exhibits? Because a lot of these cases are very document intensive.
I'll start by saying be organized. And one of the things I like to see happen is if you're going to have any discovery in advance, or even if you're going to file anything that's got an exhibit number on it, to have a unique number for that exhibit and to have that same number follow throughout the entire arbitration so that everybody knows what exhibit 1 is and what exhibit 10 is, cuts down a lot of the time discussing what the document is. But separately, I like having the parties having an OCR version of PDF so they can find things quickly if they need to, if they just remember one keyword or whatever in the document. But just like with any presentation where you're presenting to one person or maybe three who are going to decide everything, they want to see organized presentation and logical presentation and not a lot of fumbling.
Yeah, I generally agree with all that. I think organization is key. Question I had for you, Sam, Jennifer, is, back in the, I guess oldish days, you'd have big binders of paper exhibits. And at least in the arbitrations I've done recently, the arbitrators themselves don't want those big binders, sent to their house or their office. They'd rather just do things digitally. Is that what y'all have found, and what do you prefer in that regard?
Yeah.
Jennifer, I'll let you take first swing at that. Yeah.
Yes, I prefer digital exhibits. I think that it's very burdensome for all of the litigators to put together, and costly for the clients, frankly, to put together these exhibits. And then depending on the case, some of them aren't even conducive to printing out, especially if there's schedules and things like that. And then from the arbitrator's perspective, we really don't want to be lugging dollies full of bankers boxes to and from hearings, and then also finding things later, like Henry said, trying to find, the termination letter or the fourth demand letter or whatever, it's going to be easier to find it if it's electronic. I would say some other things that I've seen that haven't gone so smoothly in arbitrations is where people are using letters instead of numbers for their exhibits. And so it's letter exhibit BB and XX and whatever. It's best not to do that. And then it's best to use a prefix so that everybody knows whose exhibit it is. C1 for claimant, R1 for respondent, R22. So that nobody's just referring to exhibit 14 and you don't know whose exhibit 14 it was. And then also it's when you save them, even saving a single document or single exhibit as one PDF. I had one where it's like, open this 600-page PDF. Now we're going to exhibit 34. People are scrolling down. Everybody's trying to get on the same page. Go down to exhibit 34. It's on page 92 of this 600-page PDF. It can really slow down the process when you're trying to cross-examine witnesses and you're waiting for several other people in the room to get there on that particular page.
Jennifer, and everybody, I'm going to agree with you all about that. When I conduct these hearings, I use an iPad, and I usually have given everybody and I do that versus my regular computer because, frankly, it's not an energy hog, and the batteries tend to last the day. And it's a little bit better graphically. I can work the screen. And also because in my 60s, my handwriting is not nearly what it was in my 30s. But so I tend to do it take notes and look at the documents on an iPad. And what I do is typically give everybody a deadline to have their documents up. It'll be a few days before the hearing. And at that point, I will download the documents and put them on my iPad. And I will typically look at them as I'm downloading them so that when I walk into the door of the hearing, I kind of know what we're facing and what's going on. So I will echo what Jennifer said about numbering them. If you've got 100 documents, then it needs to be whatever it is, respondent or claimant or third-party respondent or whatever it is, put an abbreviation in there and number them 1 through 100 or whatever it is. That way we can easily find them. And as Autumn said, it needs to be a searchable PDF because I will refer to that during the hearing. So.
And I think after the hearing too, I mean, a lot of litigators are thinking about their presentation of the evidence and how they're going to present their claims with their cross and directs and everything from their perspective, and rightly so, because they're preparing for the arbitration. What some of them don't think about is when the arbitrator is going to write the award in this case and go back through the evidence and back through the testimony, how practical and efficient is it for the arbitrator to find these documents I want him or her to go back and look at again. And so that needs, if you've given them 3,000 notebooks and then expect them to write an award in 2 days' time, it's just not really practical,
All right,
I
let's move on.
interject and say there are all sorts of exhibits though that you might use in an arbitration. One of which is videos. If you have a long recording of people talking, you might want to. Well, you definitely want to get to only the clip that's important and not have 3 hours on either side of the important discussion. Similarly with photographs. You don't need to have 20 photographs of the same brick or whatever. And also any way that you can make the hearing interesting is probably very helpful because the poor arbitrator's going to be sitting there for 8 hours listening, and you want to have something they can take home with them that's memorable. And so sometimes that's video. Sometimes it's video used in cross-examination. Sometimes it's audio recordings. But you need to find a way to track those so that they can be found later, like Jennifer was saying.
And I would also add, in terms of visual aids, I have found where the expert witnesses will prepare visuals that are very helpful in understanding certain technicalities. And 9 times out of 10, most litigators are going to go present their fact witnesses first, lay out the timeline of events, lay out the contract and all of that, and then they're going to put their experts on the tail end. Which you want to just be careful of your time frame, because if this is an expert intensive case, you don't want to be having your expert rush through things at the end. And also, some of what the expert has to say can be very helpful for the arbitrator to understand a particular issue. Like I had one where the expert came and said, this is how this was supposed to be built. This is how the order in which things would be done per the plans. And then let me show you this visual of how this was actually built. This went here, this went here, this was changed to this. And seeing that kind of visual can help you understand what actually happened on that, in that particular dispute.
I'll agree with both of that. I'm a big fan of demonstratives and summary exhibits in arbitration, especially because there's less procedural hurdles than trying to, get those documents in a federal court hearing. I think they, spice up what would otherwise be pretty dry material. And they're really helpful, especially visually, to explain things, especially on a construction project where, like Jennifer was saying, explaining how a particular type of project was built, or why something went wrong through some sort of video of failure analysis. I think those are all really effective in getting your case across, as opposed to just hearing a witness talk about it.
I think you also need to think about primacy and recency. What are you going to do out of the box, as Jennifer was saying, to have these people or this person understand the overall situation? And then what are you going to leave them with at the end of the hearing? Because there's going to be a whole lot of jibber jabber in between that goes into details, and you got to figure out how to make it stick with the arbitrator.
Yeah, I think that's a good point, Henry, because at the end of the day or the week or whatever it is that you're hearing the case, the arbitrator is going to have to go figure it out. And notes are great, but I tried a case that had a huge amount of flooring problems. I mean, unbelievably bad flooring problems. Seeing those flooring problems was a big deal. And it is something you can do in arbitration. You can ask the arbitrator to go view the site. Now, unfortunately, in the legal world, we're frequently behind the time on it. So, maybe if it's a flooring case, they've ripped up the floor and done away with it. But anytime you can get some sort of demonstrative evidence that shows what's going on visually, you're really money ahead, I think. Let's talk about also at the hearing, there's really a couple of things that the arbitrator is going to want to know. He's going to want to make sure that your statement of claims and your damages, or she is going to want to make that, is up to date. So I should think you should be prepared to walk in the door and say, here's the amount of money I'm looking for. Here's what my prejudgment interest is. I'm looking for attorney's fees under this theory, and kind of lay all that out. And the opposite of that is also true. If you're defending the case, you should have a succinct summary of what your defenses are. The arbitrator needs to understand whatever the defense is. And I'm not talking about, the answer that sets up every defense that is known to man, and I do see some of those, but I'm really thinking that what you ought to have is, we really think that there should be no award in this case because of X, or maybe, that the amount sought by the claimant is $1 million, and the amount of damages really should be $250,000. And this is the time where you should be prepared to put that out. Jennifer, any thoughts on that?
Well, I think that, I don't know. I feel like I've been talking too much. Does Guadam want to respond to it first?
Yeah, sure.
I feel like I'm taking up all the time here.
No worries. Yeah, I mean that's a big part of us, when we prepare exhibits for trial, is always having a summary of damages chart or exhibit that really sets out, each claim and the amount for that claim, right? And then, tabs it up at the end with, like you said, interest, whatever fees we're seeking, and having that as a key exhibit Putting that in the opening, having different witnesses refer to it. If you have a damages expert, making that a key part of their testimony, obviously. Because ultimately, that's what we're ultimately here to decide, right? There might be some interesting or juicy facts that go along with supporting your claims, but at the end of the day, what you're asking the arbitrator to do is allocate costs, right? Is determine entitlement and quantum to however many claims are out there. And so that's always a key piece of evidence that you really want to focus on and make sure, one, that it's correct and that it's easy for the arbitrator to kind of look at the chart and get understand what exactly you're claiming in terms of relief.
In
Okay.
that respect,
I-
keep it as simple as possible. Although it might not be a bad idea if you have a complicated calculation that results and it can be condensed into a little line, 234 days times $2,000 a day, something like that, as to the rationale for the amounts, because sometimes years can go by between the time something actually happens and the time that you get to the arbitration. Sorry, Jennifer, go ahead.
And I was going to say, keep in mind that the arbitrator cannot ask you for the information that you're supposed to be putting up as evidence to prove your case. So if, for instance, you only put up the proof of your calculation of your damages, but yet you've asked for interest, and there's no mention of interest while you put up your case in chief, and then you turned it over, you're cross-examined about things, the other side doesn't address your interest claim, and there is no proof put into the record of interest. The arbitrator cannot say, oh, by the way, I see in your complaint you've alleged interest, but you've made no mention of it. Are you going to put up proof of that? Arbitrators aren't allowed to do that, because then it looks like you have the thumb on the scale of one particular side, or you're trying to help one side make sure that they don't miss what they put in their pleadings. So the arbitrator is not allowed to do that. And I did have one particular case where the person was so focused on the underlying facts and the breach of contract that they simply forgot to mention anything about interest. So there's nothing in the record over how it was calculated, from what date to what date, at what rate. And if they had prepared a summary of the claim and put that out there ahead of time, they would have that to be referring to and make sure that they've covered everything, all the elements of the claim. Because the other
However,
side's going to sit back and wait for you to miss one important element of your claim and not point it out till closing arguments or something.
you did mention something that came to mind. First of all, and luckily it was not me, one of my older lawyer friends tried a case against a younger lawyer, and since this is focused on the first arbitration hearing, somehow or another in that instance, the young lawyer never put the contract into evidence. Well, when it was a breach of contract case, so obviously the older lawyer won hands down. But what really came to mind during Jennifer's discussion is, even though the arbitrators may not be able to probe about what you're going to do about that claim, what are you going to do about that claim, they certainly can ask questions to your witnesses. And that is a very unique aspect of arbitration. And there went my light, which I knew was eventually going to cut off because of the timer on my system.
One thing that I see as a frequent mistake is, I see the claimants frequently put up their damages. Maybe it's a construction defect case and they say the damages are X. Well, it is frequent, in my experience, that the respondent's answer is basically, no, it's not. We didn't do it. We didn't do it, blah, blah, blah. But you have to think about what would happen if the arbitrator is going to find that there is a damage. Don't you want to suggest what the correct amount would be to repair it? For example, let's just take a smaller case. It's a $100,000 case. But the defense feels like it's a $10,000 problem. Well, if you ignore that, then what happens is the arbitrator, if they're going to rule for you, goes back to draft the award and doesn't have any basis for which to provide a reduced award. It's not a legal thing as much as it is a practical thing. Let's talk about for a minute. We've got about 3 or 4 minutes left, and I want to answer a couple of questions. But what about appeals from arbitrations? Do we see appeals from arbitrations, Henry?
If I can interject on that, if you agree in your arbitration agreement that an appeal can be taken and state exactly how that appeal is going to be done, then you theoretically could appeal from the arbitration award using whatever mechanism it is that's set out by the parties before the dispute ever arises in their contract. But in general, not so much.
Yeah. I'm like Henry said, unless there's some sort of contractual process, I think it's generally very, very difficult to overturn an arbitration award. I think there's very limited grounds on the FAA where it's essentially, there was corruption or fraud or evident partiality, which is a really hard standard to meet. Arbitrator misconduct. There's got to be something really unsavory about how the arbitrators went about coming up with the award for it to be overturned. The most common one that I see, at least, is refusing to hear evidence pertinent to the case, and arbitrators are very wary of that because that's one of the few grounds for overturning an arbitration award, which explains why they let in things like hearsay and are pretty liberal about letting in evidence. Sometimes they're loath to grant summary relief as well, because even if it's somewhat of a clear-cut case, they at least want to hear the evidence to prevent some sort of attack on the award in an appeal. But long story short, it is really hard.
Okay, I want to answer a couple of questions here, and let me go back and pick up Holly's question a little bit here. Apparently, there was a motion to dismiss, and I can't read a lot. I don't understand a lot about what the background of that is, but the arbitrator usually wants to allow discovery before hearing a motion and insist on setting a hearing, even though it may not be needed. From reading what you've responded to, Ms. Hempel, I think that there may be a question there when you've got a potential tort claim as well as a contract claim. There is a line of cases that deal with whether or not the arbitration clause envisions that the tort claim would be arbitrated as well as the contract claim. And there's a couple of Supreme Court cases. The Coinbase case, I believe, is one of them. And you've got to be careful with that. I will tell you, speaking from an arbitrator's perspective, I do conduct hearings if there is some sort of meat to something. That's not to say every lawyer thinks that their case is worth summary judgment, but few of them really are. Partially for what Gautam just said was that, if I granted summary judgment on it, then somebody may have a built-in appeal on that. So it's best to hear the evidence. But the second thing is I cannot tell you how many times people have told me what the evidence was going to be, and therefore I should grant summary judgment. And when we get into the hearing, it turns out, guess what? Not quite so much. So experience has taught us, and I practiced in state and federal court for a long time, and I've always wondered why judges were hesitant to grant those things. But experience has taught me that, you got to really be careful with that. We've got another question about what's a small case. That's from Ms. Johnson. And I don't know what a small case is anymore. I think we've all tried, and Henry, I'll pick on you because you and I are probably close to the same age. I've tried many a case for $5,000. But today, I think the AAA says fast track and got them. I think they raised the $100,000 limit to 150 in the last revision of the rules.
Okay.
But there's a $50,000 threshold for a documents only case, and then there's like $150,000 for fast track, and starting north of it's either $1.5 or $2 million, you get into a panel. So the cases, the higher the limit, the more complex it is. But we still see a lot of smaller cases. I mean, it's not unusual to see a $35,000 or $50,000 case. I have a case right now that I'm waiting to hear everybody's response on, but you know, they tell me it's a 4-day case and the claim is less than $100,000. So I don't know what makes sense in that, but we'll see. Y'all have any thoughts on that? Jennifer, Gautam, what makes a small case?
I think the fast track threshold, I would have said under $100,000 would be a smaller case. I think these days that's generally what I would consider as a smaller case.
Yeah.
Yeah, I was gonna say 75,000. I mean, you have to think about what it's gonna cost to try the case, you know?
Yes.
And I see people spending a significant amount of money in attorney's fees taking these small cases to arbitration, so.
So to sort of interject there, one of the things I I encourage my clients against is you can have the death by 1,000 cuts, and when you're paying an arbitrator to decide, you know, whether something that cost you is going to cost you at max $5,000, whether that should be awarded or not, and the fact that somebody has to present evidence on such claims, and if you have 20 of them and you spend $20,000 presenting $20,000 worth of claims, then you're going backwards really fast, and the arbitrator might be loath to grant a lot of attorney's fees to
Yeah.
to determine a $5,000 matter.
Yeah, that's exactly right. Well, look, I want to thank everybody for their time. We've reached the magic hour, and you know, Henry, Jennifer, Gautam, I really do appreciate you agreeing to help us out here. I appreciate everybody attending today. We do have one other question that says, can we resend the seminar materials? I think if you reach out to Lane Susselby at the State Bar, he can get them to you. And that'll help you out there. So thank you very much. And I'm going to close the video off right now. Thank you for your time.
Thank you all.
Thank you.
Today's meeting. Thank you
Great
so much
being
for
with you, Jennifer, Gautam, Sam.
Thank you all.
Thank you.